So good afternoon, everyone. Welcome back to our weekly webinar series. Today's topic is counter claims in IBC. So we are looking at extensive discussion and discussing various judgments on the issue of counter claims and also understand the because when as an RP or as a liquidator, when we get claims, we will also talk about how counter claims and how they're required to be taken care of in the whole insolvency process. Anil sir is not joining us today because Anil sir is busy at a colloquium organized at Vigyan Bhavan for discussion on IBC. So he has been spending he spent almost the full day yesterday, and he'll be spending the full day today in that colloquium discussing about how IBC can be made better. That's a initiative taken by the Ministry of Finance and IBBI. So I have with me Advocate Amar Vivek. Amar has been helping us with a lot of NCLT and CLAT matters, and is represented our insolvency professionals in various important matters. So
Hello, everyone.
I am sharing the screen, and let's start without taking further time. And as always, we will keep taking questions while we are discussing this issue, and we're looking forward to understanding the practical implications with all of you on how to address and how to take care of all the scenarios that come to you as insolvency professionals, as fellow professionals. So let's start, and to understand counterclaims, let's quickly understand and review the definition of claim in Section 3. So Section 3, Clause 6 of IBC defines a claim as claim means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. So we are looking at a right to payment, and then we are looking at we are saying that it need not be reduced to judgment. It can be, it may not be. Then we are looking at disputed or undisputed, legal, equitable, secured or unsecured. So any right to payment is required or can be a claim. Then it says right to remedy for breach of contract under any law for the time being in force if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured, or unsecured. So the scope is really wide. Then it says the expression claim as defined under section 3(6) of the code has two parts, right to payment and right to remedy for breach of contract if such breach gives rise to right to payment. Right to payment, irrespective of its nature, can be fixed, disputed. So I think that's something that is very clear, that the definition is wide and includes everything. So let's go forward and understand how the United Nations UNCITRAL definition of claim, how does that also include contingent claims? Including contingent claims is extremely important because that's the nature of the various claims that are still disputed or still under any litigation, or where there is a possibility of a counterclaim which is not yet finalized. And that's what we are looking at as well today. So the guide talks about provisional admission of claims and says that claims may also be conditional, contingent, and not mature at the time of commencement. So when entity goes into insolvency, the UNCITRAL as well as IBC, they anticipate that the claims or there is the at the stage of the company where it is going in insolvency, it is almost impossible for the company to have no litigation, have no pending disputes, have no pending claims or counterclaims, and so on. So it says that claims may be conditional, contingent, and not mature at the time of commencement. Further, it says where the amount of claim cannot be or has not been determined at the time the claim is to be submitted, many insolvency laws allow a claim to be admitted provisionally, subject to giving it a notional value. So determining a value for such claims raises a number of issues, such as the time at which the value is to be determined and whether it must be liquidated, in which case it will need to be considered by a court or estimated, which might be undertaken by an insolvency representative, the court, or some other appointed authority. So the reason being, an important reason for permitting provisional admission is to allow creditors holding those claims to participate in the proceedings, and in particular to vote on key issues such as approval of the reorganization plan or on other issues requiring a decision by creditors. It also says that provisional admission of a claim will generally entitle the creditor to participate in the proceedings to the same extent to other creditors, except that they may not be entitled to participate in distributions until the value of the claim is finally fixed and the claim admitted. Where, however, the claim is ultimately not fully admitted, any previous votes by the creditor in proceeding may be discounted in proportion to the admitted claim. So it talks about how the creditors or the claimants to a insolvency process can be protected even though their claims are not finalized and even if they are contingent. So the claims pending adjudication are referred to as contingent claims. IBBI had released a discussion paper in August 26, 2020 on assignment of contingent claims, and the discussion paper identified that there is an inherent value of all contingent claims, that occurrence of future uncertain events have an impact on the value of contingent claims, and a methodology to account for such uncertainties and ascertain the value of such claims. So thereafter, IBBI had amended the liquidation regulations to allow assignment of actionable claims, disputed claims, cause of action, and contingent claims. And therefore, all contingent claims are capable of being estimated, and an RP should be barred from rejecting them merely because they have not been crystallized. So the idea is that you're talking about two things here. One, you're looking at claims made by creditors against the CD or the company which is under insolvency. You're also looking at claims when you're looking at actionable claims, disputed claims, cause of action, and contingent claims. You're also talking about how the claims of the corporate debtor against other people can be assigned because that's an asset. So one, you're looking at contingent claims, which might be liabilities. Contingent claims can also be assets. Contingent claims can also be having a nature where there can be assets at the time of finalization of that claim or finalization of that adjudication, and they might end up being liabilities. So therefore, we say practically when we are doing a CRP process, and creditors are asking us that, okay, what kind of assets are realizable maybe against in respect of arbitration cases that are pending or that are pending in some forum, especially in case of EPC companies, especially where government contracts are involved. In many times, there might be some retainership which is still claimable from the companies which had given the company a contract, many other cases like that. And there are then counterclaims made by those people. So it can be an asset at the end of the day, because in case you net it off, it can become an asset. If you net it off, it can become a liability as well. So let's understand counterclaim, its nature and scope. So what is a counterclaim? A counterclaim is a claim made by defendant in a suit against the plaintiff. It can be described as follows. It is an independent claim. It is separable from the plaintiff's claim, and it is enforceable by cross action in favor of the defendant. So the counterclaim essentially is a cross suit with all the trappings of pleadings as a plaint, including the duty to aver the cause of action and also payment of requisite court fees thereon. While the defendant's cause of action for a counterclaim may be different from and independent of the cause of action of the plaintiff suit, and the cause of action for the counterclaim may arise before the plaintiff suit or might arise after the institution of the suit, what is required is that the counterclaim must be made before the written statement is filed or before the date of filing written statement expires. So, understanding this, the idea is that for a counterclaim to exist, or the basic definition, you're looking at a wider definition where you're looking at a counterclaim can be X party files a claim against Y party. Y comes back to the court and says X has claimed this money from me, but Y says that I also have a claim against X. It is a very wide definition. and that simple counterclaim is understood to be is what we define as a counterclaim. Since a counterclaim is in the nature of a cross suit, a defendant seeking to avail himself of a counterclaim must set out all the material facts on which he relies in support thereof with the same particularity as he would be as a plaintiff in an independent suit. So what is the court doing essentially? End of the day, it's hearing maybe multiple suits or multiple issues in this with between the two similar parties. One party says, okay, I have this claim against the other party. The other party says, I have this counter claim against the first party, and the court is hearing those matters. Those matters can be one matter related to one contract, related to multiple contracts. It can, I believe, also be based on different arguments with respect to different issues as well. So counterclaim may contain more than one cause of action, provided the different causes of action are such as can be joined in a suit as an independent suit. So as there is no vested right to a procedural law, the new law rules apply also to pending suits. Hence, where a plaintiff to the suit does not raise any objection to allegations in a counterclaim, allegations will be treated as having been accepted. So over to you, Amar. Maybe you can share about how this counterclaim process has been developed in the CPC, from which it has then, of course, come to IBC as well.
So thank you, sir. First of all, starting from where you left, as regards to the role of claim in IBC is very important. That whenever a company goes into insolvency, the first thing that a creditor is supposed to do is file its claim. Now, the concept of counterclaim, how it finds its place in the realm of IBC, it's because a counterclaim, what we usually understand, it has a very wide definition. Now, a cross claim and a counter claim first needs to be identified separately. A cross claim can only arise from a single transaction. But suppose a company A goes into insolvency, then in that case, suppose it had certain businesses with company B, and in there were several independent transactions of one another. Now, out of one transaction, the A company had a debt against B. So A owed a certain amount of sum to B out of a single transaction. But the other four transactions, A was a party who can initiate recovery proceedings against B. So in such a cases where these all four or five transactions were independent transactions, only one transaction which can be benefit, which can be shown in as an asset in books of the corporate debtor, can be said to be a claim, would not be justiciable. So that's why we have this concept of counterclaim, where all these claims of company B, where company B stood as a creditor against company A, will find its place whenever the company is also going into insolvency. So as this concept of counterclaim find its place in firstly, it was introduced by Amendment Act of 1976. Earlier to that, there was no provision of counterclaim explicitly under the any statute. So the amendment was brought in, and under Order 8, Rule 6A to 6G was incorporated. Now, Rule 6A to 6G, these are all procedural parts. Starting from Rule 6A, it says the counterclaim by defendant. So, a defendant in a suit, in addition to its right of pleading, a set off under Rule 6, set up by way of counterclaim against the claim of the plaintiff, any right of claim in respect of a cause of action accruing to the defendant against the plaintiff. Now, that's why even if we go by the words of law, it clearly says it gives very wide definition in respect of a cause of action. Now, this cause of action may be independent of that of any transaction that this company B had with company A. Now, coming on to clause 2, such counterclaim shall have the same effect as a cross suit as to enable the court to pronounce a final judgment. So whenever the court or any adjudicating authority, that be arbitral tribunal, whenever they are coming to a conclusion, so that this counterclaim and the claim filed by the suit filed by the plaintiff will be decided all together by a single judgment, so as to there will be some component of set off, and they will be left with some component of recovery, either party A or B, out of the final judgment. Now, the plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant. Now, as we generally see in courts, that whenever we file an application before NCLT, the first thing that the respondent is supposed to do, file a reply. Now, in case of counterclaim, this counterclaim filed by the defendant itself is being treated as application. So, at that point of time, the plaintiff, who was the claimant in the first place, will get an opportunity to file its reply, and that will be in the form of a written statement, which is unusual in, especially it was unusual in civil practice. So this concept was introduced for the first time. The counterclaim shall be treated as a plaint and governed by the rules applicable to plaints. So again, the same thing being repeated over and over again, that this counterclaim will always be treated as a separate suit, but the adjudication will altogether will be by a single judgment. Now coming on to the other rules, Rule 6b, counterclaim to be stated. Of course, in any claim whatsoever to be made, it should be very precise with regard to what is the ground supporting the claim and what is the quantum of claim. Exclusion of counterclaim in certain cases. In certain cases, Rule 6c says that this exclusion may be provided to counterclaim whenever defendant thinks that it is more beneficial for him to proceed this counterclaim in a separate suit. Now, this may happen on occasion of jurisdictional issue. There may be a case that a company A had 1 lakh rupees due from company B. However, company B in its counterclaim had rupees 1 crore rupees due. Now, this raises an issue of pecuniary jurisdiction, because a court having pecuniary jurisdiction of 1 lakh would not be able to entertain a dispute amounting to rupees 1 crore. So in that case, such exclusion can also be made to the extent of rest of the 99 for rest of the 99 lakh rupees, he may institute other suit. Now, effect of discontinuation of suit. In any case in which defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued, or dismissed, the counterclaim may nevertheless be proceeded with. So even in case the suit of the plaintiff is stayed, the same status applies to the claim of the status of the counterclaim. So in a nutshell, what we see that Rule 6A to 6G, they confer in addition to the right of set off under Rule 6 as well, a statutory right to file a counterclaim. What they enable a party in a transaction to put forward in a single, avoiding any multiplicity of proceedings, to in a single suit to adjudication of all the claims altogether by emanating between two parties. Now there are three modes per se of pleading or setting up a counterclaim in a civil suit. In a written statement filed under Order Rule 1, so this written statement altogether, as we saw, will be treated as in itself as a plaint. By amending written statement with the leave of court and setting up a counterclaim, however, suppose if any party was not able to bring it to the record of the court at certain point of time, they had a counterclaim. So if they can obtain a leave from the court, and then also they can set up a counterclaim at a subsequent stage in a subsequent pleading under Order 8, Rule 1. So Rule 9. So this is also one other way in which once they seek liberty of the court, they can add their pleading, make amendments to the pleading, and introduce fresh pleadings to the court, setting up their counterclaim. So,
Okay.
sir, who may file counterclaim? I think, sir, you can elaborate more on this aspect.
Right. So let me take it forward. Normally it is the defendant who may file a counterclaim against the plaintiff, but incidentally and along with the plaintiff, the defendant may also claim relief against the co-defendants in the suit. So, but a counterclaim solely against co-defendants is not maintainable. So basically, party A files a suit against party B, as well maybe co-defendants C and D, maybe the directors of the company. The directors of the company now come back and say that no, we are not this claim that has been made against us. We have a counter claim against A as well as B. Now that is possible as per this provision, or rather this interpretation of this is that. So the counter claim filed by any of the defendants can not only be, or can maybe not be limited to the plaintiff. It can also be made against the fellow defendants, co-defendants. So when counterclaim may be set up, So a counterclaim may be set up by a defendant against a plaintiff in respect of cause of action accruing either before or after filing a suit, provided such claim is not barred by limitation.
Limited.
So limitation again comes into place here, and I think apart from that, the limitation provisions that means will continue to be applicable to the counterclaim itself. You can't say that, okay, if there is a claim which has been filed maybe from within the default period of 3 years, and there is a counterclaim that somebody comes back and says, no, I also have a counterclaim, but the last cause of action that he had against that with respect to that counterclaim was 6 years back. So then it will perhaps be limited under the Limitation Act. Effect of counterclaim. So such counterclaim has the effect of a cross suit, and court can pronounce a final judgment both on the original claim and the counterclaim. The counterclaim of the defendant will be treated as a plaint, and the plaintiff has the right to file a written statement. So the suit will run as if there are two suits going on, but they are being, of course, taken care of by in a common suit and by a common court. The effect of the counterclaim is that even if the suit of the plaintiff is stayed, discontinued, dismissed, so the counterclaim can continue. If the plaintiff does not file any reply to counterclaim made by the defendant, the court may pronounce the judgment against the plaintiff in relation to counterclaim made against him, or make such order in relation to counterclaim as it thinks fit. So I can relate to, or maybe many professionals can relate to this whole idea, because when, say, we at many times we go to CIT appeals for an income tax matter and get relief on the matter or some matter. So maybe 5 matters of discussion are there, and out of the 5, 3 are given, or 3 larger ones are held in favor of the assessee. And the assessee decides sometimes that I will not fight for the remaining 2, which have been decreed or which have been decided against me. But what happens is that in case the department files an appeal uh, at IT-80 with respect to that CIT appeal order, you can then invariably we see that the assessee is then also interested to try out, or rather put in his effort and file a counter suit with respect to the 2 matters that were held against him in the CIT matter. So we see that happening in IT-80, and we have been seeing that happening in IT-80 since a long time. Now, coming to this concept of set-off. So set-off means a claim set up against another. So it is a cross claim which partly offsets the original claim. It is an extinction of debts of which 2 persons are reciprocally debtors to one another by credits of which they reciprocally creditors to one another. Where there is mutual debt between the plaintiff and the defendant, one debt may be settled against the other. It is a plea in defense available to the defendant. So defendant may claim a set-off if the following conditions are satisfied. What all? The suit must be for recovery of money. The sum of money must be ascertained. Such sum must be legally recoverable. It must be recoverable by the defendant or by all defendants if there are more than one defendant. It must be recoverable by defendant from the plaintiff or from the plaintiff if more than one. So talking about some examples of a set-off, I can imagine that, let's say that there is a contract of a corporate debtor to build a roadway for maybe NHAI on a contractual basis. Now, the contract with NHAI or the agreement with NHAI would allow the contractor or the contractor to build the roadways and claim the money which is required to be paid to him as per the contractual obligations. Now, that's one claim that is available on behalf or for the corporate debtor, that is the contractor, against, say, NHAI. But at the same time, there is a possibility that the contract also provides for penalties that are receivable or recoverable from the contractor in case of delays in the project. So those can always be, if they are crystallized, if they are finalized, and they can be set off by NHAI against the payments which are due to the contractor. So that would fall into the definition of a set off. What else, Amar, comes to your mind which can be covered, or some examples which we can talk about? Let's talk
Uh,
about, say, income tax. So income tax, again, if there is a demand or demand outstanding, let's say because of an assessment which has been finalized, and at the same time there is a refund which is recoverable at the other side, these can again be set off by the income tax department on the finalization of the matter which is under appeal, right? What
So
else?
just to clarify it a bit more to the extent of legal application, the moment we see point number two, the essential condition that sum of money must be ascertained. So in a suit of for damages, of course, you will file a counter claim.
Hmm.
It will be treated as a counter claim. However, in a suit of recovery, where the amount is ascertained, it will always be treated as a set off. So this is a distinction where wherever the damage, it may be either liquidated or unliquidated. If the amount is uncertain, then we will treat it as a set off. And if the amount is uncertain and it is to be determined and adjudicated by the court, the counterclaim will come into picture.
So counterclaim takes the color of a set off the moment the
Mhm.
claims are ascertained by and achieve finality. That's what you're saying.
Exactly.
So set off and counterclaim, let's have a look at how they can be distinguished as we were already talking about it. So let's understand the first part, that is set off is a statutory defense to a plaintiff's action, whereas a counterclaim is substantially a cross action. Then set off must be for a certain sum as it must arise out of same transaction. A counterclaim need not arise out of the same transaction. Set off is a ground of defense to plaintiff's action. In other words, the former is a ground of defense. A shield which is established would afford an answer to the plaintiff's claim in toto,
Mhm.
or pro tanto. The latter is a weapon of offense, a sword which enables the defendant to enforce the claim against the plaintiff effectually as an independent action. So in case of a legal set-off, the amount must be recoverable at the date of the suit, while in the case of a counterclaim, the amount must be recoverable at the date of the written statement. So when the defendant demands in a plaintiff's suit an amount below or up to the suit claim, it is a set of stricto sensu, which but when it is for a larger amount, the claim for excess amount is really a counterclaim. So understood. So I think what you're trying to say is that even so, the plaintiff suit, the amount due versus the counterclaims amount that is settled is also important, because in case that
Mhm.
amount is larger, then it will lose the color of a possible set off, because then you can't say that, okay, I have 100 due and you have 50
Mhm.
receivable from me, so I will net pay you 100, or
Mhm.
so that won't happen, or net 50 comes to me. So similarly, a reply filed in answer to a counterclaim shall be treated as a written statement and governed by rules applicable to written statement. So you're saying that the effect may be
Mhm.
as follows. It has the effect of a counter cross suit, and court can pronounce a final judgment both on the original claim and the counterclaim. The counterclaim of the defendant will be treated as a plaint. So I think we understand this now.
Mhm.
So let's understand now the timing, because timing of these filing these claims is important, and understanding how the moratorium that triggers on CRP commencement date affects claims or affects counterclaims. So let's try and understand that. So of course, we understand that as soon as the application of CRP is submitted under IBC, the moratorium comes into force, and the insolvency, the interim resolution professional shall be vested with the management of the corporate debtor and responsible for receiving the claims. So Honorable Supreme Court in Swiss Ribbons held that moratorium imposed by Section 14 is in the interest of the corporate debtor itself, thereby preserving the assets of the corporate debtor during the resolution process. We understand that. Section 14, let's understand this, that in Part A talks about how the insolvency commencement date, the adjudicating authority shall by order declare moratorium uh, for prohibiting all the following. What all is prohibited? The institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, uh, tribunal, arbitration panel, or other authority. So that's a wide coverage which talks about uh, what would be kept pending. So understanding this better, Honorable Delhi High Court in Power Grid Corporation of India versus Jyoti Structures in 2017 interpreted proceedings including and against the corporate debtor used in section 14. So it said that proceedings would under 14(1)(a) do not mean all proceedings. Then it says that the term proceeding would be restricted to the nature of action that follows that is the debt recovery against or debt recovery action against assets of the corporate debtor. So what are we doing when we are looking at a moratorium? We're looking at a protection for the CD so that it can survive. Because in case the CD has, say, 100 claims against it, and it is fighting those 100 claims and 100 recovery actions are happening against the CD, everyone asking the CD to pay money to the creditors who it is the money is pending against, then that proceeding the court says needs to stop. That is the debt recovery action, and that's what they interpreted. The use of narrower term against the corporate debtor in section 14(1) as opposed to the wider phrase by or against the corporate debtor used in section 33(5) of the code further makes it evident that section 14(1)(a) is intended to have restrictive meaning and applicability. So how do we differentiate this? We say that if corporate debtor has any litigation pending against any other person, where maybe the corporate debtor is required to or has some dues against some other party, those suits will not have an effect of the moratorium. But if there is any suit which is filed against the corporate debtor, that will be, of course, put to a stay during the moratorium period. Then it says term including is clarificatory of the scope and ambit of the term proceedings. So it says that when we look at including, we talk about how it is only some examples or rather clarifications on what kind of suits will be put to rest. So it talks about execution of any judgment, decree or order in any court of law or tribunal. So it talks about execution of any judgment, and it says that that is only clarificatory of the scope. So hence the question arises that how are claims to be admitted by resolution professionals where the claim is contingent and depends upon the outcome of a pending dispute. For example, in case where there is a pre-existing counterclaim pending adjudication against the counter debtor, against a CD. What if a counterclaim filed by corporate debtor is pending adjudication, and it is only when the claim filed by creditor and the counterclaim filed is adjudicated upon the RP shall be able to determine the amount of claim which is to be admitted. So let's try and answer these questions, Amar. And the idea is that let's understand counterclaim vis-a-vis moratorium now. So the question is whether the adjudication of the counterclaim would be liable to be stayed in view of section 14 of the code. Let's try and answer this question. So under section 14(1)(a) of the code, strictly speaking, a counterclaim would be covered by moratorium, which bars the institution of suits or continuation of pending suits against the corporate debtor. So we are looking at only against the corporate debtor, as we just talked about. So it talks about a piquant situation that the corporate debtor undergoing insolvency proceedings can continue to pursue its claim, but the result obtained in the counterclaim would be barred under section 14(1)(a). So there is no bar that you can't continue the proceedings, but the result of the counterclaim would be barred. So how do you talk about it then? So let's say that XYZ has a claim against the government or the government agency with respect to a EPC contract. The EPC, at the same time, the other side has a counterclaim. Now, do you then read this and say that, oh, I can pursue my claim against that person, but he can't pursue the counterclaim? Would that be right? Let's try and understand what the various how we can understand that. So it is pertinent to examine whether the counterclaim raised in a case against the corporate debtor is integral to the recovery sought by the corporate debtor. Then it is also pertinent to examine whether the claim as well as the counterclaim are interlinked to the same transaction. So when such situation arises, the court has to see whether the purpose and intent behind the imposition of moratorium is being satisfied or defeated. So in the Delhi High Court case of SSMP Industries versus Perkin Food Processors, it said that a blinkered approach cannot be followed, and the court cannot blindly stay the counterclaim and refer the defendant to the adjudicating authority or the resolution professional for filing its claim. So pertinently, the question as to whether the creditor is in fact entitled to any amount is determined by the adjudicating authority prior to the adjudication of plaintiff's claim of recovery. The same would result in possibility of conflicting views in respect of the same transaction. So these are some important elements that do you understand that are these counterclaims on the same transaction? Are they integral, or is a case which has been filed as the counterclaim integral to the recovery? So these questions and therefore are important. So under these circumstances, the High Court of Delhi held that the plaintiffs and the defendants' claim ought to be adjudicated comprehensively by the same forum. So it is important to note that there is no threat to the asset of the corporate debtor during the continuation of the suit of the counterclaim, and the same would be not adversely impact the assets of the corporate debtor. Once the counterclaims are adjudicated, an amount to be paid recovered is determined in that stage or execution proceeding. Depending upon situation prevalent, Section 14 could be triggered. So we are then talking about the issue of timing now, that the suit is pending, a suit is pending, counter claim is also pending in the same court. So the court has said and finalized that let both the suits be heard. And if there is a scenario where the net amount which is decided by the court comes out to be an amount recoverable by the corporate debtor against somebody else, in that case becomes an asset of the corporate debtor. Recovery of that will only help the corporate debtor maintain going concern, keep corporations going on, and so on. At the same time, the court said that in case it happens the other way around, where the counterclaim is held to be a stronger claim, or rather a valid claim, and the claim of the CD against the other party, the debtor, is higher, is lower, then the net amount which is payable by the corporate debtor in that proceeding will again be barred by the moratorium, because that is what is protecting the company against everyone coming in and asking for their money as it has fallen due.
So just to clarify this bit, if we see it in the other manner, the recovery in terms of Section 14 is bad. The decree at that point of time is not enforceable. So automatically what happens, these person on whose favor this decree or recovery certificates have been made, they become a creditor and they file a claim and become part of the resolution process of the corporate debtor.
Right. Very well. Very well said.
Quantified.
Yes. So their claim, and rather their claim whenever finalized, will have to be taken care of by the resolution plan as well. And that's a very important addition, Amar, that whenever there is a claim, even if it is under adjudication, we normally as insolvency professionals should promote filing of that claim, so that it becomes part of they are party to the entire resolution process. And as the various court rulings that we have discussed before, where the claims that have come in during the CIRP are not to be adjudicated by the insolvency professional, that's the final decision of various courts. The resolution professional is only supposed to verify the claims, make sure that the supporting documents are available, try to understand in case the claim amount has achieved a particular finality such that an amount can be finalized for that claim, and then admit that claim, even if he wants to admit that claim as a contingent or a provisional claim. In case there is no possibility of him or there is no document available to ascertain the claim amount, in that case, then of course we go ahead and say that okay, we will put in a value of 1 rupee for that claim and give a very, very adequate and rather a very longish disclosure in the information memorandum, so that the resolution applicant is able to take care of that matter in the resolution plan. So that's very important. So let's understand the adjudication upon counterclaims filed by or against corporate debtors. So the nature of counterclaim is such that it requires proper pleadings to be filed, defense and stands of both parties to be considered, evidence to be recorded. So the proceedings before the AA are summary in nature, and the resolution professional does not conduct a trial. So the RP merely determines that payment can be made towards the claim raised, subject to availability of funds. So the AA, the resolution professional, cannot be burdened with the task of entertaining claims of defendant which are completely uncertain, undermined, and unknown. So recourse available. Yeah.
So ultimately, the jurisdiction goes back to the original forum. Like we see when there is an arbitration proceeding going on in favor of the corporate debtor and there is a counter claim. So the ratio today is clear that that arbitrary tribunal is supposed to adjudicate that claim first.
Yes. So the original jurisdiction of the various disputes does not change. those can be put on hold in case there are litigations where or disputes where maybe whatever will come out of those disputes will finally be a liability for the CD. In those cases or in those matters, one can go to the court and say that the CRP has started. You are requested to stay these proceedings and allow the CRP to go forward so that we can spend time, or the management can spend time and resources on keeping the CD a going concern rather than fighting these cases, because those cases will eventually anyways lead to a demand against the corporate debtor, which can anyways be filed in as a claim and that can be taken care of. The other way around is that the other side of it is that in case there is a dispute where the CD has a claim and there is a counterclaim, then in many cases the resolution professional is supported by the COC to continue the pursuit of those claims so that that money can maybe come in someday. Rather, sometimes even new suits are initiated during the CIRP for recovery of money against people who have money due to the CD. So let's understand the recourse available with the RP. So in case of disputed claims are filed with the resolution professional, the resolution professional can decide the claims in the following manners. What are the possibilities? He can look into the documents, the accounts, and admit the due claims of the corporate debtor which are payable to him in terms of the said documents records, and reject the amounts which are not found claimable. So as we said, that in case he is able to satisfy himself that yes, due documents are available, supportings are available, and there is some number against the claim of the operational creditors or other creditors which need to be admitted, he will admit those claims. Alternatively, if where he is not satisfied, he will pass a decision and say that okay, I do not admit these claims, and in case there is an aggrieved creditor, that aggrieved creditor can actually go to NCLT and say that this resolution professional has not accepted my claim, and in case the NCLT says that this should have been accepted, then it can be accepted. In any case, now the expectation from the RP is that even if he has not accepted such claims, he would make these claims which are not accepted part of his information memorandum, so that if the resolution plan is sanctioned by the COC, the resolution plan addresses the issue or the liability which might arise to this creditor who has whose claim has not been admitted. So the knowledgeable those claims which RP has knowledge about, where the RP had rejected those claims, can also be then addressed as part of the resolution plan, so that there is no dispute later. The other is that in case of disputed claims, the resolution professional can notionally admit ₹1 only. So this shall assist the RP in cases where the claim is contingent and based on the outcome of counterclaim. So with respect to scenario number 1, the SR judgment from the Supreme Court of India talked about this, and it says that talked about how the resolution professional admitted the claim of the above mentioned respondents notionally at ₹1 on the ground that there were disputes pending before various authorities in respect of the said amount, and it said that the NCLT in its judgment dated 2019 directed the resolution professional to register the entire claim of the said amount. The NCLAT in paragraph 43 and 196 of the judgment talked about made this comment that they said that we therefore hold that this part of the impugned order deserves to be set aside on the ground that the resolution professional was correct in only admitting a claim at a notional value of P1 due to the pendency of disputes with respect to the in respect to the said claims. So that is how the NCLAT had identified that. So although the NCLAT had said that the complete claim should be registered, the NCLAT has said that it was okay to register it at ₹1. So let's understand some questions of law that arise due to due to the various litigations and whatever questions I've answered. So let's quickly go through these questions. First one is whether the adjudication of counterclaims would be liable to be stayed in view of section 14 of the code. So we're talking about whether section 14 puts a moratorium against the adjudication of counterclaims as well. Then we talk about whether the non-admission of claims by resolution professionals stating it to be a disputed claim pending adjudication by the Honorable Arbitral Tribunal is bad in law. So basically, non-admission of a claim on the basis that it was a disputed claim pending adjudication. Is that okay or not? Then talks about whether the arbitration proceeding pending before the Honorable Arbitral Tribunal can be proceeded during the period of moratorium. Then whether the resolution professional liquidator is duty bound under section 25(2)(b) of the code to take up the issue of counterclaim either before the adjudicating authority or DRT before proceeding with CRP and liquidation proceedings. So should he wait, or is he duty bound to take care of these counterclaims before he can proceed with the CRP? Should CRP and liquidation proceeding wait for this counterclaim issue to be sorted out? Then does the filing of counterclaim before the DRT prior to commencement of CRP impact the CRP proceedings? Whether the pendency of counterclaim proceeding before the Honorable DRT be a ground to stay the distribution to financial creditors during liquidation. So let's understand this first one. And I think we have already talked about this in some manner. We talked about the Jharkhand Bijli Vitran Limited versus IVRCL. It's a national NCLAT judgment from 2018. The facts of the case are that the prior to CRP commencement, the proceedings pertaining to the claims of the CD and the counterclaims of the appellant were pending before the arbitral tribunal. And in the meantime, CRP was initiated against the CD. So in view of the application filed before the Honorable NCLAT, the NCLT white order allowed the corporate debtor to pursue the claim before the arbitral tribunal. So agreed by the said order, an appeal was preferred before the NCLAT. So submission of the applicant was that the question of determination of counterclaim during the period of moratorium should have been decided by the adjudicating authority without leaving it open to be decided by the arbitral tribunal. So, so the claim was, and the question was, that the adjudicating authority, NCLT itself, should have decided the question of determination of counterclaim rather it being left out to the arbitral tribunal. So the submission of the RP for CD was that they have no objection if the counterclaim is decided by the arbitral tribunal. So the appellant said that why shouldn't the counterclaim be decided by the adjudicating authority itself? The CD said that we have no issues, which authority takes care of this issue. So it was held that the claim of the corporate debtor can be determined only after determination of counterclaim made by the appellant in the same very arbitral proceeding. And in counterclaim or part of it is set off the claim made by the corporate debtor, the claim and counterclaim of the parties should be heard together by the arbitral tribunal in absence of any bar under IBC. So, however, on determination, it is found that the corporate debtor is liable to pay a certain amount. In such cases, no recovery can be made during the period of moratorium. So, as we said just now, and we summarized a while back, that's how the law reads, that the proceedings can go on, but if they're settled against the corporate debtor and there is a liability for the corporate debtor to pay, that liability is affected by moratorium. Let's also understand the other case that we had discussed briefly, the SSMP Industries Limited versus Perkin Food Processors Private Limited. It's a July 2019 judgment. So again, here, let's see the facts of the case. So the plaintiff, corporate debtor, and the defendant claimant had entered into an agreement. In pursuant to the said agreement, supplies were made, amounts were due from the defendant. Plaintiff, corporate debtor, thereafter filed a suit seeking recovery of 1,61 lakhs, and the defendant claimant had filed a counterclaim in which he avers that they are entitled to 59.51 lakhs. So during the continuance of the proceeding, the plaintiff, corporate debtor, went into insolvency. So the corporate debtor had filed a suit asking for recovery of 1.61 crores. Counter claim had been filed for 59 crores. There was still about a crore rupee or more than that recoverable from the corporate debtor in this manner. So the claim of 59 lakhs for the defendant claimant is in the nature of a set-off, and it is intertwined and interlinked with the plaintiff. So we just talked about set-off a while back. So here, in case you see, both these claims are crystallized claims. So that's how then it says that they are rather a set-off, or they need to be understood in the nature of a set-off. And therefore, it is not an independent claim by the defendant claimant, but it is to be adjudicated in the light of the claim made by the plaintiff, corporate debtor, in the suit. In that sense, at this point, the claim itself is not yet adjudicated, and it is not even clear whether any amount should be recoverable by the plaintiff or corporate debtor. Both the suit and counterclaim ought to be adjudicated together instead of the defendant claim being forced to approach the resolution professional for recovery of its claim. So Reliance was placed on Jharkhand Bijli Vitran Limited, and then further the alliance was also placed on Power Grid Corporation of India versus Jyoti Structures, where the High Court had observed that the continuation of proceedings which do not result in endangering, diminishing, dissipating, or adversely impacting the assets of the corporate debtor are prohibited under are not prohibited under section 14(1)(a) of the code, what we just discussed. So submission by the plaintiff corporate debtor was that the counsel for the plaintiff corporate debtor submitted that he has no objection if the suit and counterclaim are adjudicated before the court. So it was finally held that the counterclaim does not deserve to be stayed under section 14, and it was observed that the counterclaim filed by a defendant claimant would be a proceeding against the corporate debtor. However, it is interlinked with the claim by the corporate debtor, and therefore also integral to the recovery sought by the plaintiff and the corporate debtor and ought to be adjudicated. The NCLT RP cannot be burdened with the task of doing this, and since the counterclaim are adjudicated, once the counterclaim are adjudicated, an amount to be paid recovered is determined at that stage or in execution proceedings, depending upon the situation prevalent, section 14 would be triggered. So that is how this judgment, or rather the first question, gets answered, that counterclaims will be taken care of by the original jurisdiction. Let's put that to finalization. So the question that we were asking is clear, that the moratorium will not be liable to be put to rest. The moratorium will not put the counterclaim to rest. The counterclaim will keep on going, and once it is decided, in that case, if there is a liability against the CD that is held, then section 14 will come to place and rescue the corporate debtor against any liability. So Amar, let's take up question number 2. You're on mute, Amar.
Whether the non-admission of claim by the resolution professional stating it to be a disputed claim pending adjudication by the honorable arbitral tribunal is bad in law. So in this, sir, the first judgment that comes.
So let's summarily talk about all the judgments, because we have only 7 minutes remaining. So we can just give a brief idea about the upcoming judgment.
So this Ultratech Cement Limited versus Minata D. Rajan, so National Company Law Tribunal judgment. In this, the contention was that whether how the resolution professional has to deal with the claims with regard to disputed and contingent claim. The corporate debtor has initiated arbitration proceedings prior to the initiation of CIRP. Applicant filed its counterclaim, and the CIRP of the corporate debtor was subsequently initiated. Claims were invited. Applicant accordingly submitted its claim before RP. The claim of the applicant was rejected, stating that the amount claimed is disputed and is pending adjudication before arbitral tribunal. Now, what it was ultimately held that NCLT relied on the judgments that we just discussed and clearly held that the amputation of term claim under section 3 subsection 6 is very wide, and it confers it to the meaning that it includes a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. Therefore, that the counterclaim filed by the applicant before arbitral tribunal is said to have a claim, the same is contingent upon adjudication, and hence the claim is necessarily to be declared as a contingent claim. It cannot be rejected. Rather, it will be declared as a contingent claim, and it will become part of the information memorandum.
So as we discussed summarily, the counterclaim or this claim which has been filed has to be made part of the IM, even if the RP is of the opinion that I'm not able to put a value to this claim. So you will have to maybe put in a rupee, give a rupee 1 value there, and say that it's a contingent claim, make it part of the IM so that it can be dealt with by the resolution applicants.
Correct.
So let's understand this question, whether the arbitrary proceedings pending before the Honorable Arbitral Tribunal can be proceeded during the period of moratorium. So again here, this was Subodh Kumar Agarwal versus EIH Limited, NCLAT 2019 judgment. Skipping the facts of the case, let's try and understand that what were the various submissions made here. So the question relating to the continuation of arbitral proceedings was, it was based on the issue decided by the Supreme Court in Alchemist Asset Reconstruction Company versus Hotel Godawan Limited, Private Limited versus, and also at KS Oils. So in the said case, the Supreme Court had observed that the mandate of new insolvency code is that the moment an insolvency petition is admitted, the moratorium that comes into effect under section 14A1 expressly interdicts institution of continuation of pending suits or proceedings against the corporate debtor. In case oil also, it said that the adjudicating authority has no jurisdiction to set aside the order passed by the Indian Council of Arbitration. So these two judgments were read together, and the counsel for the respondent then also submitted that the arbitration has been instituted after the aforesaid moratorium is non-extant law. So it was held that the counterclaim made by the corporate debtor is a separate proceeding than that of the arbitral proceedings filed by the claimant. However, they cannot be segregated. So it said that because there is already a claim filed by the corporate debtor, the counterclaim has to be taken care of in the same proceedings. And for that reason, so they had the view that the appeal is squarely covered by the decision of arbitral tribunal case in KS Oils. And they said that in such a situation, it cannot be decided as to what amount can be taken. We hold that the counterclaim filed by the corporate debtor also cannot proceed. So both were so basically the claim of the respondent cannot be determined by the arbitral tribunal during the period of moratorium that was finally decided in the process.
Now, so coming on to the fourth question, whether the resolution professional liquidator is duty bound under section 25 to take the issue of counterclaim either before adjudicating authority or DOT before proceeding with CIRP or liquidation. So this is a question which has much relevance in CIRP process today, because today we see the IBBI is giving so many orders with regard to duties of the liquidator and resolution professional. So in this, there is one judgment which we will be referring to, Vishal Doshi versus Bank of India, NCLAT. So in this, what happened that Section 7 was filed before adjudicating authority seeking initiation of CIRP. Appellant, one of the suspended directors, challenged the order on admission on the ground that the debt has been satisfied and set off in diminution of amount rupees 1,561 crore against a debt of 226.50 crores. The corporate debtor had availed certain credit facilities from financial creditors. The corporate debtor's account was classified as NPA, and it was stated that the corporate debtor replied to the notice setting out that it was facing temporary financial difficulties. Thereafter,
so there was an NPA. ICICI had a claim of 226 crores against the corporate debtor. However, there was a claim filed by the suspended directors that the financial creditor had taken away, or rather had taken control of inventory worth 1,561 crores. So they said that we don't need to pay anything, or rather there is no liability here. Rather, we need to recover this amount. So that's how I think the facts were stated. So in the DRT, the ICC had filed a case seeking repayment of this amount, 1.65 crores, 165 crores along with interest. So, right, and the appellant submits on receipt of valuation report that the total stock was 1,561 crores. So that was the kind of difference. And the valuation report showed a stock worth 1.199 crores. So the issue was with respect to what was the stock value that was seized from the CD's premises. I think that was the issue. Now let's understand what were the submissions made by the appellant, the respondents, and what was the final decision taken.
So, sir, ultimately what happened that adjudicating authority felt that they should not trouble themselves with this question today of what is the quantum of claim. It ought to be decided before the DRT, and it should go before the DRT in all sense. And adjudicating authority has no locus to decide the quantum of claim today.
So they simply refrained from going into this dispute and said that this has to be taken care of by the court or by the tribunal which had original jurisdiction over this issue. So let's understand this question. Does the filing of counterclaim before the DRT prior to commencement of CARP impact the CARP proceedings? So now we are talking about a counterclaim which has been filed at DRT prior to CRP commencement. How does that impact the proceeding? We're talking about a judgment from 2022, which is Abdul Rahim versus Justin Joes, the resolution professional liquidator. So the appeal has been filed by suspended managing director of Sargam Builders, who claims to have some good percentage of shares of the company and also claiming to be one of the unsecured creditors for 2.22 crores. So it has been alleged by the appellant that the IRP and financial creditors in collusion admitted wrong claims, and it says that it said that uh, various counterclaims of the appellant against the FC before the DRT was pending for consideration, and counterclaims was not considered. So what was the question? They said that the suspended managing director said that you have admitted 100 rupees as the claim amount when you have given the rights to the financial creditors, but you have not taken into consideration the counterclaims that have been filed by the suspended directors or by the corporate debtor against those financial creditors. So say ICICI Bank has say 100 crores due, and the counterclaim is also pending at DRT. So when you're accepting the claims, will you subtract the counterclaim from the claim amount and then accept the claim? That was the question that was answered here. So let's understand the decision. So it said that it was held that there was no error on part of the resolution professional and the adjudicating authority, and therefore there was no requirement to interfere in the subject matter, and the appeal was failed. Then, based on the detailed deliberations and reasons, this tribunal, bearing in mind the surrounding facts and circumstances of the case in a conspectus manner, comes to a consequent conclusion that no case is made by the appellant. So hence, mere filing of such huge counterclaim before DRT doesn't impact the CRP proceeding. So it said that you just can't say that, oh, there are huge claims pending as counterclaims, and that would decrease the claim amount further. So there's no adjustment that you need to do there. So
So
Amar,
with
the
regard to the
sixth,
sixth question,
yeah.
whether the pendency of counterclaim proceedings before the honorable DRT be a ground to stay the distribution, because as we just saw that it wouldn't stand in the way of CIRP process altogether. So would it stand in the way of distribution once the company goes into liquidation? So this question was considered by court in case of Kotak Mahindra Bank Limited versus Ashok Oswal, suspended director. This judgment is a recent judgment of 2022. The court clearly came to this conclusion because the facts were simple, that there was a DRT proceeding going on before a particular DRT, and there was a distribution that was supposed to go on while the pendency of that proceedings before DRT. So the liquidator approached Kotak, one of the secured financial creditors, approached NCLAT against a judgment of NCLT, wherein NCLAT also clarified that no, during the pendency of counterclaim of the corporate debtor, it cannot be a ground to stay the distribution of the proceeds coming out of the liquidation process. So in no manner, and we clearly see that the wordings of section 53, it is a differently worded section, that it opens up with the non-obstante, that notwithstanding any law made by the parliament. So in any manner, distribution cannot be stayed merely on the ground that there is a proceeding going on before the DRT. So that was what was concluded.
And
by the
also, I think in practice, what most liquidators are doing is that they are always asking the persons who are getting the distribution to give a document and rather give an undertaking that in case there is any change in the distribution because of change in the waterfall mechanism or waterfall that would be available to them, then they will be liable to pay that money to the other creditors who would of course fall in line with respect to that change in the scenario. So that is also covered there. And of course, we have seen in a few cases, I would say, where this has actually happened. So let's quickly conclude that I think we understand that the proceedings before the adjudicating authority are summary in nature, and the resolution professional merely determines what payment can be made towards the claim raised, subject to availability of funds. So neither the adjudicating authority nor the resolution professional is expected to finalize the claims that are contingent or disputed. They only have to collect the information, put it in the information memorandum, and try and find a solution or find a resolution plan, because that's their primary duty. They are not here to finalize all pending disputes that are pending at some forum or the other. Now, in this, so let's understand that the adjudicating authority, resolution professional, cannot be burdened with the task of entertaining claims of the creditors which are completely uncertain, undermined, and unknown. So, in that case, as we say that for claims which are completely uncertain, undetermined, and unknown, that 1 rupee formula will work, where the RP can say that, oh, I cannot give a value to this claim because it is still at a very primary stage, and let me give a value of 1 and make adequate disclosure in the IM. So uh, it is also pertinent that the suits pertaining to counterclaims are tried before the appropriate authority. So claims as well as counterclaims will continue to be pursued at the appropriate authority. We cannot say that these will be taken over by the adjudicating authority or suspended because of the moratorium coming into place. The result of Section 14, as we said, will not have adversarial effect on the assets of the corporate debtor. However, the same shall help the resolution professional to determine the amount of claim. It is also pertinent to state that the significance of counterclaim can be seen when the CRP proceedings are sought to be initiated under Section 9 of the Code, and there is a pre-existing dispute with respect to the claim amount mentioned in the demand notice. So that is also something where we have discussed that and concluded that. And since the pre-existence of counterclaim shall determine the admission of the application for initiation of CIRP. Then the last part, since the claim amount of creditor is subject to outcome of counterclaim and the same is contingent in nature, that 1 rupee process can be followed to give a value to all the claims which are still at an early stage and still under a dispute. So wherever the claim is ascertained by some authority and still pending for final adjudication, there maybe the RP should most probably give a value to that claim, and at the same time understand if there is any and also talk about the dispute that is pending in the other forum, where the dispute is still at an early stage. There has not been any determination with respect to the value which is payable or payable against that claim. Again, the 1 rupee formula should work, and whenever this determination is happening, any claim and counterclaim should be considered in the overall decision of the RP. Both information on both should be provided to the resolution applicants in the IM, so that they can take care of how they want to settle these litigations and take care of that. In many cases, there might be a possibility that once the resolution applicant takes over the company as a successful resolution applicant, then they might fight on behalf of the CD and settle the counterclaims and make the claims against outsiders, debtors, enforceable and realize money out of that. So that is also an important part of those people, or for those people who are making these resolution plans, to make sure that they're protecting the eligibility of the CD to continue litigation against those people where there is a possibility of any recovery coming in to the corporate debtor. So that's also important part of the resolution plan. So I think that's about it. So to summarize, we have one question coming in. Advocate Pradeep Lokhande has said that the Arbitration Act, DRT, SURFACI, he says, how do you talk about the intersection of these acts also? He says that, and of course he talks about how the rules and concepts of IPC or of CPC have been adopted in the NCLT cases. So we here today then discussed how moratorium affects these counterclaims, how the claim process, which is part of a core part of the IBC, is affected due to any contingent claims, any pendency of any matters, or if any counterclaims which are pending anywhere. So whenever we talk about Arbitration Act, DRT, SARFAESI again is is an act where the banks have a right to take over the mortgaged asset and liquidate that asset to realize the outstanding money to them. That act would, of course, has given a good power to banks to settle the entire matter out of court. Of course, SARFAESI also has a provision where if there is any dispute from a plaintiff or from an entity or from a person who has some property, he can go to DRT and get a stay over the SARFAESI proceedings. With respect to other proceedings in DRT where financial creditors or other creditors have filed some proceedings to recover dues, as we said, those will continue to be there. In the DRT, one can again
So,
have a counterclaim.
so
Yeah.
just to clarify this bit to
Mhm.
this answer, that our discussion is with regard to counterclaim and their treatment. So counterclaim could only arise in cases where the corporate debtor was in itself a party initiating the litigation suit. So in all these cases, in DRT, the corporate debtor cannot be certainly a party who has initiated the list. In SARFAESI, the corporate debtor cannot be a party who initiated the list. So in both these cases, moratorium would come into place to the extent that these proceedings are adversarial and cannot take place. However, in arbitration tribunals where corporate debtor has initiated the list, Section 14 would not come into bar, but where the list was against the corporate debtor, it would act as an impediment.
And in cases where it was against the corporate debtor and the corporate debtor has a counterclaim of a higher
Again,
amount, there
same.
again it will continue
There again,
because there again there
again,
is a possibility of
uh,
recovering that amount. But
hmm.
wherever it will only result in a liability, they're investing in that and crystallizing that liability may not be something that the RP or the COC would be interested in pursuing.
Interested in pursuing, exactly. So it becomes a practical and case to case situation.
Practical case-to-case scenario, Net-Off says that wherever
Hmm.
there is a feeling on part of the CD, on part of the management, on part of the RP or the COC, that the net result of any claims and counterclaims is that some amount will be realizable. There they can continue the proceedings. Where they feel that no, this will result only into a liability, pursuing that case will be futile. There they can enforce the moratorium and say that we would like to put this on stay as long as the CRP is going and protect other interests of the CD. So great, Amar. Thank you so much. And I hope
Thank you, sir.
this very important issue of counterclaims was addressed by us. And we're looking forward to another session next week and looking forward to you joining us next week as well. Thank you so much for joining us. Looking forward to be with you next week. Thank you.
Thank you, sir. Thank you, everyone.
Thank you.